mean, I can send, Safe Bill over there, you know, they can, you know, inspect it and all that stuff, but that's as far as I can go.
Okay.
You know, without something in writing, you know, I don't.
Gotcha. Okay. Any other questions on the zoning administrator report? If not, then we'll move on to the trustee report.
We also held one special meeting September 3rd, I believe I did put on here. Basically, the only thing we did with that was, we had to approve removing people and adding people to the bank account.
Okay. You say advertise for landscaping, you're talking about like.
They advertised for bids
Gotcha.
to do landscaping on the 2 road frontages along the back of the building and the east side of the driveway. And then there were some discrepancies in the bids as far as including other things and not including some of the things. And there were some discrepancies, so we decided to table it. The supervisor was supposed to meet with the 2 contractors, and the bids they're unsealed, but they were all put away, nobody ever discussed prices or anything. Therefore, hopefully the bids are still good, just gotta get amendments or corrections or whatever.
I assume by the time they get it approved, it's gonna be a next year thing. Yeah.
I don't know. I don't get it. I don't know.
Other than maybe leveling out the stuff.
Yeah, I don't know. I mean, I can tell you, the state is still doing road projects and still seeing in the future here, so. They've got projects that just started now, so they're nowhere near ready to start seeing.
Is there gonna be a temporary assessment?
Nothing like that was discussed, and I didn't write down the dates. She will be completely off for a certain period of time, and then she'll work from home for the rest of the time. You will still be able to reach her by text or voicemail or email, and you can even do that during the period when she's completely off. As soon as she comes back, she'll start going and answering the oldest first.
Gotcha.
I didn't write down the dates, so I can't tell you that.
Okay, any other questions on that report? If not, then we'll at 7:15. We'll open the public hearing for HPG LLC special land use permit renewal. This is where's this one located at? This is over on Sugar, off Sugar area.
Yes.
Anybody in attendance of the meeting tonight received notice for this renewal that will just speak at this time? Gotta say it every time. If not, then at 7:15, we will close the public hearing. And we will move to planning commission and discussion. One thing that jumps out at me right away is nowhere on the application other than the parcel. Oh, there it is. There's the street address. We might need to update the special use zoning permit application to put a place for the parcel address, because it's not on that anywhere. Just as a side note, I didn't see it until we got to the medical and adult use marijuana application. And then is it being issued to Jamie Rogers, or is it being issued to HPG LLC? application is to Jamie Rogers, and the special use permit renewal is to HPG LLC. So which is it issued to? Is it issued to Jamie Rogers' name, or is it issued to HPG LLC?
I guess it would be HPG LLC.
So then the medical and adult use marijuana facility establishment permit application needs to be updated to make sure that the right name is on there.
Okay.
And then also, notices and all that were sent out,
Yes, yep.
and no problems with this property?
No, I didn't have any complaints or anything like that. One time this summer I drove by, their grass was kind of long. I sent them a message to take care of that. They had it done by noon the next day, so no issues.
Are they actually operating out there, or is it? Okay.
Help me out, because I know I'm missing it. Never mind, as I said that, way down here in the little print, I couldn't find that address either.
Yeah, that's what I'm saying, we might need to update the.
It's just they typed in a smaller font, I guess.
Yeah, definitely want to update the permit application with the right name, because we got Jamie and Heather, so Jamie Rogers and Heather Brink signed for it, so we need to know if it's actually being issued to the LLC.
Okay.
And other than that, I don't see anything. Oh, yes, I do. Carrie didn't sign it. Or, no, never mind. The signatures on the wrong pages. Carrie did sign it, never mind. The signatures are both names. Though Heather and Carrie didn't sign the renewal application. They signed the one, but they didn't sign the other. So they should, I guess, they should at least sign the applicant's signatures, and if Jamie is the sole owner and property owner, then that's right, but should determine whether they're all co-equally owners of the property.
Okay.
Anybody else with any corrections?
Don't see anything else.
Okay. Okay. Nobody else has got anything, questions or concerns on this?
Before you get into that, nobody else has questions, so I'll wait for that. I just screwed up and wanted to say during my report, we have a new member. I know you know that already, but welcome Gloria. And do you have any questions, being new? You sat out in the audience for a few of these, so I don't know if maybe you got it down or not. If you have any questions, ask away. Understand, you know. That's all I wanted to do. Quick, I'm sorry.
Then in that case, I will make the motion to conditionally approve, renewal of HPG LLC's Class C, MMFLA and Class C, MR, TMA, special land use permits with correction to issuing name on the permit application and any special land use permits? I mean, we've always done anything like that. Yeah, we've got a couple of minutes before the attorney can get on. I don't believe you guys tabled any other permits from last meeting, correct?
We did?
Did not.
I thought she said we did.
While we're waiting for that then, because that would be agenda item 12, we'll just jump down to agenda item 14. There was a request by the administrative assistant who also takes our minutes that if we're going to be discussing the zoning ordinances and going through it like we did last time, that we set a special meeting for it. We'll suggest that it is a good idea because they will tend to run long if we go through a regular meeting. So I'm suggesting what we did previously, so it would be the second would be our regular meeting, and then the fourth Thursday of the month would be a special meeting and we will only do zoning ordinances at those meetings. And we'll try to keep it to an hour and a half tops is the suggestion. Is everybody okay with that?
I had no problem with that, no problem with it, ask when we got the rest of that, so.
So in that case, I'll pull up the calendar because so that means then I will be setting a special meeting for the 25th to begin at 7 p.m. And we're just going to do these as special meetings until we're through. And then once we are done, and I will send this off, I'll make sure we compile all the corrections, send the corrections to Roe to make a true final, and then this will have to be posted for a period of time. I think it's 30 days. And then we'll have to have a special meeting, or a public hearing for it, to move forward. So, I mean, hopefully, if with an hour and a half, we can make it through quickly if we're just focusing on the ordinances. So, be prepared for questions for the 25th.
Says you.
All right, so we will, with that, how do you pronounce your last name, sir?
It's Coaches.
Coaches? Okay, so we'll
Yes.
we'll begin our discussion with Mr. Coaches, who represents the township, about the dangerous building ordinance that we are helping the board of trustees develop. So I will open up the floor to questions for Mr. Coaches. Anybody's got anything? Nobody's going to start, and I will start myself. We have two different versions of the dangerous building ordinance that's floating in front of us. One was a much more trimmed down version of the first one that we received. When reviewing it, at least my two biggest concerns was there's a section on notifying the local either building authority or the clerk if you're going to have a building unoccupied for more than 180 days. So if it's like a temporary use type thing. We're just concerned, like, what is the logic behind having that time frame?
So when I look through your work, you found that a lot of times the buildings or it might appear that something is, and depending on your level of burdens and enforcement, you might get complaints on that property, and then sometimes you get issued citations too, depending on what type of condition it's in. So when you see something that says 180 days, that's usually to at least put the township on notice that it's going to be unoccupied for whatever reason. And generally speaking, when we're talking ordinance enforcement, no matter what type of ordinance enforcement we're doing, communication with the township is typically paramount. Because in my experience, especially in Tuscola County, what I see is the citation that get issued over there, it's the property owners are making contact with us. Or maybe sometimes they do it, or it's not consistent, something like that. But that's ultimately what leads to citations. What I always tell municipalities is that issuing a citation going to court is a matter of last resort. We always try to figure out a way to resolve these the best we can without going to court, because there's costs associated with that. We'd rather, if there's a way to work that out where the property owner takes care of the issue itself, then we prefer that. So that's where 180 days comes in. I don't think there's necessarily a magic number with 180 days. It just it depends what the use of the structure is, and it allows the township to keep record and be on notice that it's not going to be occupied.
Okay, and then the other part between the two that for me was a concern was there was no path defined to appeal the decision to list the building as condemned or a dangerous building.
Yeah.
So, can you speak to why that was maybe removed in the second draft version that we saw?
Yeah, so when you talk about an appeal, there's two different ways that we do ordinance enforcement, right? You could do what you're talking about as dangerous buildings hearings, and that's the built-in appeals process, and you need a construction board of appeals, which I'm not sure you have. So that's a process that goes outside of court. That's not actually through court. It's through the township. It requires a procedure where there's notice. You go here's to township board from that. So that's what I believe you're referring to as far as an appeal level. With the way some of these ordinances are structured, it's just dangerous building to issue a citation for it. If you look at your ordinances, there is there's different standards that defines dangerous buildings, and it goes on to say, you can't have a dangerous building, and the penalty is a civil infraction. So it's really a matter of preference by way of how townships want to proceed with dangerous buildings. And there's really no right or wrong answer. If you're asking me, I prefer just a citation going to court. I think it's a little quicker, and also I feel better when there's a signature from court, like a judge, on something that's authorizing us to do something, particularly when a remedy could be demolition of the structure, right? So I feel like having a court signature, it just maybe means more. Okay, that's maybe my personal opinion, but that's the differences there. Curiously, do you have a construction board of appeals? Is that something has anyone mentioned that or discussed that with you?
We don't. I mean, there was, in the way that was laid out, it did lay out maybe a means to establish one, or at least a rough skeleton. And that's why it was like, okay, well, it kind of gives you the route on how to do it. And just, my question on it was like, why did it get removed when it does seem like it would be nice to give people a way to fight it out. No, not fight it. That's a bad word for it. But to ask why it's being found as a dangerous, condemnable building, and appeal like, well, how to a serviceable building instead of taking it to the court.
Yeah, that's a reasonable alternative to doing what I just described. It's typically when you talk about demolitions of structures, right? It's what are we talking about in Vassar specifically? When I generally do dangerous buildings, it's typically that abandoned home. Maybe there was a fire, something that's in such bad shape it's not livable, and sometimes you even see through it, right? Like that's what I'm referring to in my mind when we enforce against dangerous buildings. And sometimes, it's even cases where people walked away from the property for whatever reason. So, those are the cases when I can see where there's clearly really no opportunity to rehab because of the condition of the structure. That's what I think sometimes then is, you just go to the court and you get your, you get your order to do what you need to do. Other times, like the Construction Board of Appeals that you're saying, it does provides notice, similar to, court has notice too, but also it gets you in front of a Board of Appeals that hears it, and there's going to be a hearing officer that ultimately makes a call. So, I think it just depends too, how do you intend to enforce this ordinance in Vassar? That's something I'm not really sure about. How do you intend to enforce it? With structures that are salvageable, I don't think I would use the dangerous building statute necessarily. If someone actually wants to rehab it and that's possible, I would probably refer you to International Property Maintenance Code. Within there, it talks about different, like what you're discussing, like ability to, to rehab and things like that. I would refer you to that potentially, but this is all policy decisions of the Township Planning Commission. I'm just not sure how you intend to enforce your building ordinance, your dangerous building ordinance. What's your intent there?
Isn't it important? It doesn't matter what our intent is, it depends on what the ordinance says, right? I mean, the zoning administrator next month or next year, and his intent's different, or a different supervisor. They're gonna go with what this says, right?
Okay, so I think the decision then is if we want to go back to Construction Board of Appeals, we can do that. We can add that in there if you would rather have that alternative to court. That's certainly that's something we have to do.
Yeah, I mean, I get what you're saying in terms of very clearly, this building is, one good stiff breeze away from, falling over. But I think, some of the things that were in the two different versions where it's all it's based off of this amount of damage and, off of the current building code where it's some of the structures that are in the township right now were built under very different building codes. So if you're trying to compare the amount of damage and the structural suitability of the building to new building codes, to us it seemed okay, well now you're getting into a realm of somebody's my house was built in the 1950s and I've got to compare it to building codes established in 2025. The building is not built to the same level of structural stability potentially. So a 25% damage, depending on the person making that decision, could ultimately come down to the whole building's got to be condemned. That's I think what we're more concerned about is the application of some of the wording in what building code you're comparing it to define it as a suitable structure.
Okay.
And then as Ben said, people's opinions change, people's agendas change. We want a way for it to be maybe a little less directive of a person making the decision and having a group of professionals that you can appeal to and be okay, well tell me why this is, before it's going to the court and I mean, I don't know how the process would work in court, but my concern there is that you've got a judge that maybe he's never looked at a building, making a decision based off of, you know, not knowing, like, can this building be rehabbed or not? And anybody else?
Well, that comes down to, you do have a committee though, of the qualifications of that committee. You got a contractor that can
Right,
speak
well,
to.
it was spelled out in that, like, you'll have, you know, the contractor, general contractor, you'll have, I think, Safe Built, somebody, a representative from Safe
They
Built
go
there.
by the international building codes. And they, you know, they make the determination right now, whether or not the structure is safe. You know, so there's your professional that's doing that.
But I agree with what you say too, that there should be like a board or something where people can address their concerns and say, or at least give their intent on the building. So we're gonna know whether they're gonna be putting money into it and bringing it up or not.
I mean, I get where, the attorney's coming from, like, there are, we know of buildings around here that are very clearly, like, just need to be torn down. But, you know, there was is it double wide or single wide that's on the corner of 15 and Haynes?
Right.
Like, there was a fire there, and I don't know what the interior extent of the fire was, but, you know, there was definitely fire damage there. Well, if you're comparing it to today's building codes of trailers versus when that trailer was built, like, I think that was what was, like, some of the concerning wording in the ordinance, because it's comparing it to today's building ordinance, not necessarily the building ordinances.
Well, if it's getting rebuilt, then it has to go for.
Well, the rebuild has to be to
Yeah.
today's standards, but the structural integrity of the rest of the building.
I understand what you're
Yeah.
saying. Most of the places around here, actually, pretty much all of them, it's just, the property owners just don't wanna do that.
Right.
It's simply just, you know, nobody's forced them to do anything, so they're just gonna leave it. It's like people that let their grass grow
Right.
3 foot high. Nobody says anything to them, so they just let it go. That's the way it is with 4 of these units around here that are.
Right, but I guess to that point then, do you think even taking it to court would force them to do it?
Well, no, but it gives us that step, that we've got that taken care of, and then we can go on into the next step, which is to get somebody to go out there and clean it up. You see what I'm saying? Because it's gotta go on steps, so he's gotta go back and get whatever it is, a judgment or something from the judge, saying that we can go on that property and clean it up, because we gave them whatever, this 3 months to clean it up, they didn't do nothing with it, don't look like they're gonna do anything with it. So then he gets the judge to sign off on it, we send our company out there or whatever to clean up the property, and we'll send them the bill, they don't pay the bill, then it goes on the tax roll.
Right. Yeah.
Correct? Am I right, Seth? That's Troy.
Yeah, just a couple of comments about anytime you go to court on a dangerous structure, a court, assuming the property owner shows up, a court is almost always going to give them multiple opportunities to figure it out. Okay, very rarely are you going to just go into court, have the property owner show up, and say, I want to try to fix this. And the court says, no. And then gives the township a demo order. Typically with appliance orders that I do for dangerous buildings, what happens is, I mentioned Safebuilt, you mentioned Safebuilt, you work with them?
Yeah, Safebuilt, absolutely.
Yeah, so a lot of times what happens is, Safebuilt's involved way before, I'm involved, the attorney's involved. And they go through, work with the property owner to figure out, what the problems are, what needs to be done, so on and so forth. And a lot of times when we structure compliance orders, it's more about, you set like goals, okay? Like, for example, pull whatever permits, within, depending on what they are in the condition of the structure, within a certain amount of time, right? Begin construction, get inspections, things like that, and you sort of, you lay out a plan, basically, right, of what they're allowed to do, or what you want them to do, I should say. And and see if they comply, right? And I would say, here's someone that wants to rehab the structure. I think courts are going to give them every opportunity to do that, and I think even my recommendation to the township would be like, if they're going to, try and it's financially feasible, then, let them, and then, at some point, yeah, maybe it does come an issue where it doesn't get done, you gotta move forward. But the other thing too is that, Tuscola County ordinance enforcement, is a little different than the other counties we've been in, so, that's still a process that we're working through. We've been getting results, but that's just another, I guess, aspect of it. It's more my problem than yours, to work through. Look, either way is a good way to proceed, right? I'm not necessarily advocating, court over construction board of appeals. I'm just telling you what the options are. And construction board of appeals, I think if someone goes there and there's someone that needs to be rehab, fixed, whatever it is, and sets forth a plan. I think they're gonna give them that opportunity, right? And then just tear it down. So it's really a matter of preference of what we think would be better for your township. Your township better than me. And if you think construction board of appeals is the way to go, then we can go that route.
Bob, you had a point?
We have several places in the township that's been there. I agree with something's happened and they're trying to work, maybe they're waiting for insurance companies, maybe they're waiting for something to do something. We have so many structures in this township, and nothing has been done to them in years. We shouldn't allow 180 days for them to sit there when they've already sat for 3 to 5 years, and then are you gonna wait for some kid to get in and get hurt? Or some girls get raped out of them before we do something?
Are you looking at your copy, because that's not what we're talking about.
Well, it's true, it's done.
No, the 180 is a whole different thing.
He's mentioned.
No, the 180 days was like there's two different stages to it. So there's a house that's been unoccupied, that's not up for sale for it's not abandoned. It's like, for example, my grandfather's house. It has been sitting there with nobody living in it for almost 3 years now. They intend to sell it, they just put it up on the market. There is a thing in there, it's like basically if my grandfather's house, after the first 180 days, it sat there without a occupant and without a for sale sign up, like Safeville could start going through the process of not condemning it, but marking it as a dangerous building. Then there's the other one that it's like, the example that I used was a hunting cabin, where you are basically spelled out, you're required to notify the township that it's going to be unoccupied for a period of more than 180 days. Or I think it's either township or law enforcement or both. Actually, I can't remember because I don't have a copy in front of me, I forgot to grab it. But those are two different things. What you're talking about is spelled out more clearly in the rest of it, where it's all like, hey, this is very clearly like, fire damage has damaged more than 25% of the structure. Like, those are almost, like the way that it's written is almost immediately condemnable.
Over 50%.
Whatever the percentage was.
It has been for a while. But, we were talking dangerous, and that's what I was talking about, like, your grandpa's a very good example, Glenelg. That's not a dangerous structure, but I do understand what you say paragraph 18 or whatever is, because it's been occupied now, it can be classified, but I'm more or less, I'm trying to go on the ones that are unsafe, unrepairable, and maybe that one paragraph should come out, like you say, just because it's for sale, and it's not a dangerous, it's not a health issue. I think maybe you eliminate some of the paragraphs or do something, but you just can't keep leaving them sat there and wait for somebody to get hurt.
I think the majority of the time, if you give somebody, say, 3 different choices that they can make to correct this, they're going to pick one. But if you just go to them and say, look, it's done, it's temporary, tear it down, then they're going to do nothing but that. But if you say, look, you can fix it up yourself, bring it back up to where it's not safe, you can tear it down yourself, or we can tear it down, and you give them an option, they're going to pick something.
or they'll say city, or
Well, that too.
I guess the other thing then, because you mentioned like Safeville has, can give like a compliance plan. Would it be worthwhile to spell something like that out then in the ordinance where like Safeville as the representative of the township has the authority to establish a compliance plan for buildings which are deemed rehabable? Like, is that something worth then spelling out? Because like right now, like, at least the way that I read it, and obviously I'm not as well versed in the legalese of it, but to me it's like, oh, once you go through this, like once it's been deemed dangerous, like there is no way to stop the train other than going to court.
Well, so I've never seen that type of language entered into an ordinance before, but I think there are ways to address this. Typically, when Safeville or really any ordinance enforcement, when they start a process of looking into, they get a complaint on property, they go investigate dangerous buildings in the situation. They'll start sending letters. Okay, hey, it's a notice of violation. Here's what the issue is. Okay, it's issue A, B, C, and D. Okay, those are the violations that we've observed, and here's how you can get in compliance. So usually what you'll see is that's when Safeville will start to build the file, and you'll see all the communications that they attempted to have with that property owner, okay, to fix the issue. Dangerous buildings, maybe it's a situation where instead of just, this is different than just like blind or junk vehicles, right? Maybe it's a situation where before there's any sort of an enforcement action taken, the ordinance officer goes to the township board and asks for approval to issue a citation. That way there's no, surprise about what's happening. You know exactly what the history of that property and what they stand. You can see exactly what level of cooperation or progress has been made on that construction before you decide whether or not you go to court. I've seen townships do it that way too. The difference being, there's a lot of resources to get involved dangerous buildings. Okay, like, if you're going to issue against dangerous buildings, like so often out of townships, they get a compliance order for demo, but then they don't do anything. Because, look, it's going to cost a lot of money to tear a building down, right? If it depends on the structure, it could be $15,000. If there's asbestos in there, you're going to go probably in the mid-20s. So, oftentimes, I get demo compliance orders for townships, and I say, okay, here's your order, curiously, what are you going to do? And a lot of times they say, well, I'm not going to do anything. I'm like, okay, so, at that point, I'm not sure if we went to court for an order that you're not going to act on. So, what I sometimes tell townships is, look, I know that everything's expensive, I know budgets are, limited or constrained to where they're at, and a lot of times, like when I teach on this for MTA, I tell townships is like, prioritize what you think the issues are, right, every year, because maybe you can only do, you take the worst one first, right, and you figure out, okay, well, if we're going to enforce against this either through court or construction board of appeals, and if it gets to the point of demolition, then we're going to plan to allocate X amount of money to abate that dangerous structure, per year. That's more of a budgeting issue, but that's how I see it sometimes get worked through, just because dangerous buildings is more involved, and if you're gonna tear down structures, it gets expensive, and you need to, are you gonna follow through with that, right? I know it's a school account meetings. It seems that when I've been there for court, and I did it to school township, when we got dangerous building, like a demo order, I was specifically asked, are you acting on this order? And, in the school township's case, I said yes. And we're not there yet with the school township, but we're getting closer. So I don't think the court there wants townships to be coming to court asking for orders without acting on them. That's been my experience so far.
I couldn't ask questions. First thing is just because of what you brought up. Does Tuscola Township have this exact same ordinance, or do they have a different version? Represent them all right, right?
I'll let me pull it up here. So the second one I'm looking at in front of me,
I guess, are we all looking at the same one? This is the one that we received at the 6/12/25 meeting. And I know we talked about it again on the 7/10/25 meeting.
Yeah,
This is the one.
the more pared down one that doesn't have
Yes. Okay.
the appeals for it, yeah.
Unfortunately,
Okay,
there's
so
no
you-
number on it to be able to tell you which copy I'm looking at, so. Do you know what copies you sent him, Troy?
I sent him all the copies.
So how does he know which one he's looking at?
Well, maybe he can read off the top line or something.
Hey, I don't know what's different, so I can't, you know. It's, 1, 2, 3, 4 pages long.
Alright, you should share,
Oh, I thought we lost him.
it's very hard to see, I don't know that I can make it better.
Well, if he's in the same one, we can find our information, you know, but there you go.
So, that's,
Title is the same, anyhow, yeah.
that looks like the one that we're talking about, the more pared down.
yeah. So I believe Tuscola Township does have the reference to construction board of appeals in there. So that would be the difference, I think, between what I'm looking at here, the pared down version, and Tuscola Townships.
Okay, so that brings up my other questions then. Throughout this document, it talks about everything has to be done to new codes. It doesn't actually, the way I'm reading it, it doesn't actually say the damaged portion has to be brought up to new. So I don't know, shouldn't some wording be in there? I mean, if your house is 30% damaged, now you have to build a complete modern house. Depends on the person interpreting it, I understand. So that's one problem. I'll just go through my questions and somebody can take over them or whatever you want, or I go back. It brings that up several places, so I'm gonna skip that question, it's the same thing. So J, I believe, and I think we discussed this at great length at, July 10th, the whole J needs to go. That 180-day thing, which is not what you were thinking about, different 180-day thing, that whole thing needs to go. This is a township where we have lots of seasonal people and people that go away for different periods of time. I hate this, and by this definition, if you're gone 181 days, your $500,000 house is now a dangerous building.
Right.
By this definition.
Yeah, who keeps track of 181 days?
Somebody might,
No, but that's the same.
Angry neighbor.
angry neighbor might. Let's say you're gone for half the year scheduled, everybody knows it, you didn't bother to tell everybody like you have to according to this ordinance. Then you get sick and the doctor says you're not leaving for 6 months. You come home, you ain't even got a house. Or you get served all the paperwork while you're in the hospital, wherever you're at. I think J needs to go, the whole thing.
Or needs to be reworded.
Just pull it up.
Yeah.
That solves the problem.
Well,
If you have a dangerous building, you have a dangerous building. If you have a vacant building that's not dangerous, who cares?
but I think this also gets back to like, in the zoning ordinances that we're doing with Row, they're, they put the use has been abandoned
That's a
for a
totally
period.
different thing.
But I think that's where that 180 days, based on the way Seth had explained it, that's kind of where it's coming from, is it gives you a benchmark to,
Call it what you want. Your grandfather's house
Oh,
should
no.
have been bulldozed years ago by this definition. Forget any other reasoning.
No, I don't disagree, so like, that's the way I interpret it too.
This should go. Anyway, section 4 is the whole thing about violation. I have a couple part question about that. We have a whole schedule of fines and fees separate in our township for all ordinances. So in that reasoning, does this belong in this ordinance, or should it see that and be in a different ordinance? That's part of the question.
I recommend it right here. The reason why I recommend this is because every time I've been to court, the judge wants a copy of the ordinance, and he wants a copy of this very provision that says enforcement, violations, and penalties. it's right here laid out. And given the difficulties we've had there, I don't want there to be a situation where this is a non-zoning police power ordinance. So it's standalone, and it can have its own penalty section, as you see here. I don't necessarily, with that court at least, feel comfortable referencing a different penalty section. Like in your zoning ordinance, you're gonna have a penalties and enforcement section that is likely gonna say if any provision of the zoning ordinance is violated, here are the remedies. That's typically how that works. Your zoning ordinance, it's also a couple hundred pages long probably. This right here, it's much shorter ordinance, enforcement violations of penalties. It's a standalone ordinance. Yeah, I would recommend that just to streamline this, to keep it in. You could change the fines how you want if that's not consistent with your fine schedule and how you want to do it. Yeah, we
We can change the
we
amount.
can change that.
You do recommend it be here, that's the first part of the question.
Yeah, number 4, I would recommend.
But that just makes gotta keep an eye on it in the future. Township changes something, you gotta change it 2 places. And that's what happened in the past, that got forgotten, so we had ordinances out here that contradicted other ordinances for different fines.
Yes.
They wouldn't enforce this because of that. Anyway, and then my other question about that is just about, I thought we want the thing fixed is the point. But yet we talk about in fines and fees about each day is a new offense and each day is a new fine and all that. Isn't there a better way to word all that? When do we find somebody and when do we not find them if what we want isn't fixed?
So, the language you see in is generally consistent with a lot of ordinances, potentially zoning and non-zoning ordinances. What I typically do when I'm in court is, I don't see that this isn't a moneymaker for a township, and even, say someone pleads guilty or responsible to civil infraction, right? See that the first violation is $75. The township's getting 30 back. Okay, so it's not like this isn't a moneymaker. What I typically do is say, look, I would rather you, the property owner, keep the money for yourself to work on building this, fixing whatever you've got going on with this house. So if you're willing to continue to work with us, I'm happy to waive fines and costs. If first that's what the township wants me to do, and secondly, that sometimes they'll look at So that we see every day as a separate offense. First, I do think that's true, but I would never recommend that you issue a citation every single day, right? I don't think that's the court will not be happy with that. Sometimes what I've seen, and this is kind of extreme, but I've seen this happen quite a bit, is if it's a situation where someone's in non-compliance, that type of provision, the courts will actually levy that like a daily fine to get people to force compliance. That's usually done against corporations, but it's also a remedy of last resort. But again, if you don't want that in there, that's easy to take out.
The everyday thing.
Well, I can tell you from experience that whatever we have as far as fines, the court up there, they just throw that out the window, they make their own fines. Matter of fact, I can't even write a citation and put a fine in there. They'll give me the citation back and say, we set the fines. And that's what they have done for the citations that I have wrote.
But it sounds like this might be different from the aspect of, I guess that is maybe more of a question between you and Seth than of, to get clarity on having the fines defined in here. Because like when you're writing a citation for a zoning ordinance violation, that's from the fee schedule, not from a fee set up in the zoning ordinance.
Yeah, it is. It's right in the ordinance.
Is it?
Yeah.
It's not supposed to be. It's supposed to be separate, but I mean, it could be that it's not been updated.
No, what are you talking about? In the ordinance, it's supposed to say you're subject to it, and then you have to see the schedule of fees. That what you're talking about?
Yeah, it's in there from the fees on, if somebody, doesn't permit the yard or whatever it is, you know,
There are subjects and fees, fine.
yeah.
Well,
So-
saying you're subject to the fines is one thing. Having the fine, what Ben was getting at was having the fine written out in the ordinance.
Yeah, my only problem is the location as far as, I mean, it doesn't, I have a question about how we use it, but should it physically be there, or should it say, see the schedule of fines and fees?
'Cause I think that-
He's saying it should be here for the court reasons, and I can understand that, I'm not arguing that. I just know we ran into a problem with that years ago with a different situation, a different court, and it wasn't building ordinance.
And Troy, to speak to, if you're talking it's in the zoning ordinance itself, I know the new zoning ordinances wrote specifically stripped out mentions of specific fines, because if we ever wanted to change it or adjust the fines or anything like that, we've got to go through the whole, like, we're making an amendment, now we gotta send it to Tuscola, and like, it
That's
just has
because
to
it's a
be.
zoning ordinance, and like in this case, though, it would be a general ordinance. And the fees were the general ordinance. That way, the zoning ordinance said see the schedule of fees, but now should change it anytime.
Right.
All right, so just to recap quickly then, my things are this. Anywhere that it mentions everything has to be built to new code or new whatever, I would like to see something broke down a little bit better there. Explaining it more. I understand the part that's damaged needs to meet modern code, but it really, I don't think it's spelled out very good in here about the whole building and so on. Then all of J, in my opinion, needs to go, and I know several other people agree with me. I don't know whether we are gonna do that or not, that's just my opinion. And then the violation, the fees thing, just basically about the daily. I would just feel better if there was different wording. I don't care, like if it's judged that you gotta do it, then boom, you didn't do it within the whatever days the court gives you, you owe another fine. I'm fine with that. I'm just not fine with it every day, because now you get a zealous zoning administrator and boom, 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 you got 50 tickets or something.
Right.
So if there's a better way to word that, I would prefer that.
Yeah, so for level two. Yeah, I'm gonna, I mean, I just deleted the line right now, right? Like a track change, to get every day the violation is permitted, exists, constitutes like a violation, let's get rid of that, okay? I recommend get rid of that. I don't, quite frankly, I don't want that either, so I did get rid of J. And then I had I couldn't quite hear the other stuff, it was something about construction, you wanted some clarity on,
It was, I think,
Missed that word.
clarity, it's clarity that and correct me if I'm wrong, Ben, but clarity around that any path to remediation, however you word that, like, basically, the fix is to current code, not the establishment of the safety of the building, of the structure itself being compared to current code. Like if it's damaged by fire, or if it's damaged by fire, you're not comparing the suitability of the structure to current building codes. You're comparing it to the code that it was built under, and then any fix of that has to meet current building code. I think it's clarity.
That's basically what I'm trying to say.
If that makes sense.
so I just want to make sure I have it clear. So let's go to that language that allows the damaged or unsafe portion, correct, to be
Yes, I think.
with, did you say that like the updated or review?
Yeah, that the damage or unsafe is basically determined against the code of built, like, so the safety of the building itself is judged against the code that it was built to, but any fixes meet new building code. Which, I mean, the fixes meeting new building code, that makes sense, but the way that it's being determined that it's no longer safe, because, and I get back back to the example, a building built in the 1940s is built under a different set of standards compared to today's building standards, right? So, like, just making sure that people are protected from a standpoint of, like, somebody gets a bug up their butt and says, like, well, it doesn't meet today's building code, I think is where we're concerned about.
I understand. So I think what we'll do is, I've tracked some changes here, but like they're more notes for me than they are some, final formal language. But I'll see where I can, and I don't know if you can see I shared the screen, I don't know if you can see it or not, but what I did was, I'm gonna look to see the add language that allows, it requires, I should say, the damage or unsafe portion to be fixed in compliance with new code, but when we're looking at whether something is dangerous, we're comparing it to the code that what was it built under.
Yeah, and then I think one thing maybe Ben you didn't capture, but there was a question of, so like the zoning ordinances and all that, we define who is in charge of making that determination to enforce.
Yeah.
And like how do we need wording in here as to who is enforcing it? So whether that, like, we know ultimately it's going to be safe built, but should it be like this is enforced by the board of trustees appointed representative or whatever that wording is to show who is actually responsible for enforcing the ordinance.
So,
And the labor remediated.
Yeah.
Local.
Right.
Indirect, well, take out J, that's where it references the building.
The building code or
Township building department, so
Yeah.
it references it if you keep J, if you get rid of J, then it's done. And we don't have a building department to remediate any of
And
this.
that's why I thought we had agreed that it would take out not just safe built, because we could change different companies.
Right.
It's
Well,
whoever was doing our
that's-
building codes is the ones that set the rules in our, because we don't have a board.
Right, that's what I'm saying, is that there's some wording that says enforcement by a board appointed entity or whatever, that however that wording needs to be, but that,
And then
It's
currently that's safe built, but.
right,
And that's what we didn't want to put in safe
Right, we don't
built.
wanna put that word
We
in.
don't wanna
It's
put that in.
whatever is regulating our inspections and our ordinances.
right. It's just, there's gotta be some, I guess, correct us if we're wrong, does that wording need to be in there somewhere, that's to who is the authority that is making these determinations for enforcement? Like, Troy and Rachel are, by their titles, are called out as they are enforcing these. Does there need to be a wording in this to say a board appointed codes authority or something like that?
to me, I understand your question. So, in order for us to issue a citation, if you're going to go with a dangerous building, you need someone who's going to be qualified to say this is a dangerous building and here's why under what specific code. So that's probably going to be safe built. So that's the person that I think is interpreting your ordinance to say, does it fit within the definition of a dangerous structure? Okay, I think that's the first step. But the step that I think you're asking about is who makes correct me if I'm wrong, who makes the final call whether to issue the citation and move forward going forward? Is that what you're asking about?
Essentially, yeah. I mean, even if it is safe built, just like it defining who is the issuing authority of we're moving forward this as a dangerous building. Because we have it defined everywhere else that like this person, the zoning administrator is issuing the citation and moving it forward through the process. Like who does that and how is it defined in here and we're just not seeing it, or does it need to be added?
Along with that. Along with
No, it's not in here. Oh, okay, it's
Along with that.
generally it is there's going to be someone who's authorized to enforce ordinances Okay, the court usually wants some confirmation of that, that way they know who's ever showing up to enforce a citation is actually authorized to do so. So I think what we can do though, is I think we can add a provision here, something to the effect that the township will designate whoever, you fill that in for who you want that to be, as the authorizing agent of who can issue a citation. But some is talking kind of off the cuff. But you can add something like that in there if you would like. That's really a policy decision. It's really however you want that to be, we can do.
But is the court gonna require that be a part of the ordinance they're gonna ask for? Are they gonna require you to call out or define who is doing the enforcement?
No, not necessarily. Typically what will happen is, anytime I've been in formal hearings on this, you get your building inspector on the stand, and it's where you employed, how long were your duties, are you familiar with this case, what's your role? Okay, and then that's when you start telling the story of the property as a result of whatever it is you did. What happened? I issued a citation. Are you authorized to issue a citation? Yeah, how? By board action. Like something like that. But that doesn't mean we can't put something in here. If we're more comfortable with that type of language in there, we can do that. Like there's plenty of times I've done ordinance enforcement officer ordinances that specifies exactly what the duties are for your ordinance enforcement officer. Okay? And it says exactly what they're authorized to enforce. You don't necessarily need that, but it clearly says what the duties are. And if that's something you want, you can send you a sample or whatever. But we could also put, we could add that language in here if you'd like. I don't think it's required, but you could add that in there.
Okay, anybody else? Yeah, go ahead.
We don't have a board, as you know, and I can't believe the township, it's just me, can't believe they're gonna pay people when we're already paying safe bill to do that, and, they have the credentials, not saying we can't get people from this township, 4 or 5, 3, 2, whatever you decide, have to be more than 3, at least 3, I would think. But you have building codes, they're qualified, we already have a contract with them, and I don't see this township paying for another group. I don't have a problem with that, but I just think we're already covered with the current contract, and it's clear that our zoning enforcement officer can write citations in our ordinances, even the fines, well, like, go to Tuscola County, you know, and I know, Tuscola County, they run a completely, we'll just say different, I won't say weird, type of court, but I think Daryl, in this particular case, is enough payment and has the credentials. That's just my 2 cents worth of.
Well, I think my concern with not having the appeals process was it wasn't clear that there is a way to rehab the site. But it sounds like the way Seth's saying it is, on his personal experience with Safeville, like, they are doing that on the back end anyway. It's just not.
1, 2, or 3.
Well, no, he's saying it before it goes to court. Safeville is giving people, if the building is recoverable, Safeville is already giving them the option and path forward and setting those standards. Correct? Is that okay?
Yeah. Build on that too is, and I'm going to say real quick bit, but a lot of times what I say is like, look, if you're going to issue a dangerous building citation, give me a call first. Because I want to see the type of work you put in before we actually go to court. I'm not saying that they're not doing their job. It's just that if I think there should be more, do more, because court is a matter of last resort. And when you go to court on any enforcement action, you gotta be right. Okay, there's gotta be a reason why we're there. Okay? This isn't criminal. We're there because it's a quality of life ordinance that we're trying to enforce. So I need to see the paper trail, and I need to see pictures, and I need to see what work has contact that has been with the property owner and how that's progressed. I would never if someone's there and wants to fix it, I would never recommend that you just issue a citation. No, that's not what this is. You gotta go through that process. And I mean, again, of course, it's not a lesson. If you can get it fixed on its own, try to do that. You work with the property owner the best you can.
But,
Yeah, two more further points about this. So I'm gonna go to the first thing, that's the code authority or whoever. My thought was, shouldn't it say here somewhere who's authorized to do it? And I mean like this, zoning enforcement, or whoever our law enforcement is, and code authority. That's what I meant. Should it be like multi-tiered? So Safeville does not drive around our township looking for dangerous buildings the way I understand it. Somebody has to say, go look at this building. Does that person have the authority according to this ordinance? There's nobody in here that I see. So wouldn't it be good to say the zoning enforcement, the law enforcement for the township, and the code authority for the township? That's the first question.
Yeah, it's got a note to look at.
Okay, so that's what I meant, something like that, where it's 3 departments or whatever.
Right.
And then the other thing, go ahead.
Go ahead.
Well, the other thing is about, like Bob was talking about a whole other board. I guess I didn't picture having to hire another board. Can it be something like, if it's gone through Troy and it's gone through Safeville for the first step, but before it ever gets to court, can't they come before a group, the planning commission, the zoning board of appeals, somebody? Isn't there a group that could be that authority to go over? Maybe you got an overzealous person again. Yes, you can repair that wall. You don't have to tear the whole building down. I don't know.
The way that
It has to be a higher.
the way that was outlined in the other one is it's like you have to have like a contractor, you have to license.
That was the other one. This one has nothing, so that's why I'm asking, is there in between?
And I think that brings me back to, before we're out of state, if there's concern about when a citation gets issued or who makes that call, then I recommend that you can't issue a dangerous building citation unless there's a board action approving it. That could be something as simple as Safeville providing their case report, like all the work they've done to the board and making a recommendation. And if the township board thinks that that's enough to go through, to issue the citation, fine, go ahead. And if not, then no. That way there's at least a step in there that the township is aware of before something just goes forward.
I do like
See
that.
that.
That it has to go before the board of trustees as the.
So in that example, for hypothetically here, the zoning enforcement, in this case Troy, sees it, recommends it to Safeville to check it out. Safeville does a report. Now the board has to say yes, go forward, no, or something. In your example, correct?
I couldn't quite hear everything. I heard. Go ahead.
Yeah, so Ben was saying, like, basically in your example, Troy would see, like, hey, this building is falling apart, he would get Safeville would do their report, then Safeville would present that report to the board of trustees, and the board of trustees would say, yes, issue the citation, no, don't issue the citation, because we don't feel you've done due diligence on this report, get more information before we approve moving ahead with this. Is that what you're getting at for like a whole website?
Yes.
Okay.
How about that?
Yeah.
That's a good concept.
Everybody. Yeah. I think everybody's kind of in agreement that seems like maybe the kind of language to add is that the board has final say before a citation is issued.
Okay, so I think the ones made, either way will work, whatever you need.
Yeah, I think
The first way is adding it in the ordinance. The second way is the board makes a policy and the township board would, but I think I could just add that in the ordinance. The township board shall approve any enforcement action before a citation is issued to this report. I think that's, I'll wordsmith that, but I think that's the intent of what we want.
Yeah, I think historically, I mean, anybody just feel free to disagree with me, but just making it policy doesn't always seem to follow through, so I think we want it spelled out in the ordinance, yes?
I agree.
Yeah, we want that spelled
I
out.
wouldn't use exactly that kind of wording, but yes, it should be the ordinance.
It's in the ordinance. I already tracked some changes in there, so I think, well, like I said, we'll revise this stuff, we'll track changes so you can see easily exactly what we did, okay? And then, let me know if there's more stuff that you want changed, whatever it is, we can do that too.
Just what about what I suggested about the 3 entities? Is that in there somewhere now?
Yeah, and look at adding language that states who's authorized to issue citations. That's,
It's in there now?
he's got it right above the adding it into
Okay,
the.
all right, thank you.
Yeah, so that's what I was going to do. Looking at adding language that states who is authorized to issue the citation. But first, I mean, in some ways, it's going to be the township board because they're authorizing it. They're authorizing the enforcement. I think it would likely be, you know, the ordinance enforcement officer would actually be issuing the citation. Does that make sense?
I didn't catch what he said. I didn't understand what he said.
He's saying since the board of trustees will be ultimately approving the issuing of the citation, it just stays, basically, since Troy, in conjunction with the officer, are the ones already given the authority to issue the citation, so the board would be.
Right, that's all I was questioning. Should that be in here along with safety?
I mean, I think if the township board is making the final authorization of who can write the citation.
As long as it makes sense, once we read it.
Okay, anything else?
You know what else I can do for you too?
I have one question.
I can give you a summary of maybe a resolution that the township court can consider for something like this. Because when you go into court, and so if I'm adding this in as an ordinance standard, the court's going to want to say, prove to me that the township board issued that citation, or authorized the issuance of that citation, because if they did, the rest of it doesn't matter. Okay? So I can put together like a written resolution for the board to do every time. It's just, it's a form, right? Like you just go in the blanks. But that way, if there's ever a situation where you have to go to court, got the resolution right here. I think that'll be helpful.
Okay. Bob, you had one last thing?
I have a question on this. We have square footage for homes in this township. Now, this is also an ordinance here. Now, what happens if we have a structure here, exactly what we're talking about, whatever we finally decide, 50% gone or what? If it's on a private road, our ordinances, regardless of what they say, whether it's square footage or if it's this house or what, it wouldn't make any difference, would it? You do not need, if they're in violation of ordinance 101 or ordinance 210, it makes no difference if it's on a private road, does it? It's a violation, period.
Correct.
Okay, so this said if it's on a private road, someone has to, on the private road, has to turn in paperwork. That's not true, because it's a clear violation. Our ordinances state throughout the township. So that's on any ordinance, correct? This one or any other one?
Correct.
Okay, very good. Thank you.
Okay. And anybody else? All right. Thank you, Seth, for your time. We appreciate you helping us work through this. Look forward to seeing the draft that you come up with these few changes.
Yeah, and I think maybe a way to streamline this too.
Oh, the computer just died.
Oh, man.
The computer just died.
Plug it in quick, charge it.
It's completely dead. It's like, yeah.
So you could learn a different plan. This is
Well, anyway, yeah, we're yeah, I
You
think,
can look at the other camera and finish your sentence to seven.
yeah. All right, one thing I did notice that I missed is I jumped right over, receiving and setting public hearings. There are two to set. He just, if he's got any, I mean, we were signing off anyway, so just let him know his computer died. You can message him. Yeah.
Before you jump.
Yeah, so, DRJC Holdings One LLC is, approval for medical class A and adult use class C, and Camp Cabin, medical and adult use provisioning center. I will make the motion to set the public hearing, for DRJC Holdings One LLC, special land use permit renewal, and Cabin special land use permit renewals to be held at the October 9th regular planning commission meeting that begins at 7 p.m.
Is the Canada one, is that, yeah, that's that Thomas, that, didn't have the name on there quick, it does down there, I found it.
Yep.
What?
Do I have a second?
October what?
October 9th, the next regular meeting. Sam seconds, so I have a motion and a second, to set the public hearings for DRJC Holdings and Cannon Cabin renewals, to be held at the October 9th meeting that begins at 7 p.m. Any further discussion? If not, all in favor? Aye. All opposed? Motion carries. And I'll try to remember what Rachel know. Okay, thank you. I completely forgot what I said. Parks and Recreation request. I think we've got one capital request. You should have paperwork in front of you that shows the proposal for the project. It is to put in playground mulch. It is a total of $19,450. The first part of it is the installation of 4x12 timbers with spikes and a wheelchair ramp. So that's about $3,100, and then the rest of the cost, which is roughly $16,350, is to buy the 220 yards of playground certified mulch for the appropriate fall height, depth, and the underlayment and staples. And it includes all labor, mulch, underlayment, and staples. It just does not include the cost of the timbers, which the township would purchase separately, which is a line item on here.
I have a couple quick questions on that. The installation of the provided 88 4-foot by 12-inch timbers, are they 4x4 by 12 in feet? Are they 4 feet long, 12-inch round, or square timbers?
I mean, it's 88 of them, so you have to do the math. It's probably 12 foot long, and then
That's what
probably
I thought. It says
4 by 4.
it says 4 foot by 12 inches.
Yeah, I think that's just
And I heard him talk about that day, but I didn't know that it said this, so I don't know what he said.
I bet you it's supposed to be a 4 by 4 by 12 foot, which is probably what it is.
But I know he was talking about depth, so 4 inches may not be deep enough. I don't know. Does anybody here know what was at that meeting?
Yeah, it's the board just to hold the wood chips in place, so it doesn't have to be that tall.
Well, you're using that border height as your minimum fill level, because that's what we were supposed to do.
That's why they're 12 inches.
I think the one you're looking at is for the handicap wheelchair access. That was
Yeah, it says installation of customer provided 88 of them in parentheses, 4 foot by 12-inch timbers with spikes and 1/2 ramp for wheelchair access. I don't know what a half ramp is either. I didn't understand that. Into the approximately 100 by 75 foot.
I believe what they mean by half ramp is only gives you so it's up. It goes up the timbers, and then because the fill mulch will be at the level of the timbers, you don't need a second.
Back
Yeah,
down.
we need another
tier.
Yeah.
It's all one tier.
Yeah. But, I mean, so it says it's 100 foot by 75 foot. I bet that 88 timbers is because it's multiple stacked on top of each other, and they're 12 foot long.
So they might be 4x4s, 4 inch by 4 inch,
Right.
12 foot long, and somebody just put the mark wrong.
Correct. Yeah, I think that's what it is.
And the only other thing I wanted to say is, we don't know that fee, it looks like, because they wrote in 3,100, but down at the last thing, they say it's 3,200 approximately.
Approximately, yeah.
So, you might have to put a little bit of leeway in there if you go forward.
Well, yeah, and I mean,
Part of the problem is also because if we don't get it done this year, next year, the prices may change. So,
Yeah, but that would be part of the reason it's approximate. He flat out said, if you get it done this year, it would be this price. I mean, that's what he said verbally.
right. But is that 3,100? Is that?
I assume they don't know exactly, that's why it's got 31 in one place and 32 in another.
Yeah. I mean, I would just say round up, you know, to give some leeway on the total price that they got there for overages, because I'm sure once they go put those timbers in, they're probably gonna hit some sort of hiccup to prevent them from putting the timbers in at the right depth to make the mulch the right depth, so.
We'll need an extra roll or something.
Yeah, so it's probably worthwhile to say, like, yeah, we could approve up to $20,000 spent. I mean, that's probably still not gonna cover much, but it will at least give you enough leeway for a timber here or a timber there.
the other
Or if
thing,
the ramp is a little bit more expensive than expected.
the other thing that he mentioned when we came to our meeting, that we don't have to cut that tree down, we trim some branches up, that'll give us the clearance on the swing, where we still meet compliance.
Yeah, you probably want to leave that tree there anyway, for the shade.
Right, but at first we didn't know if it was gonna be compliant, and said we trimmed some little
Sure.
branches,
Yeah.
it'll be compliant.
Okay.
I'll make a motion to accept this.
At the,
I agree with what you're saying, Dale, around at 20,000.
so motion to approve, spend, or recommend approval, rather.
Well, this is a proposal for a budget, so yeah, we're approving the budget.
Well, we're recommending approval to the board of
That's,
trustees.
that's from this budget, correct?
Yeah.
We're recommending.
For spend up to 20,000. Okay.
I'll second that.
So I have a motion and a second to recommend approval of the spend up to $20,000 for, the park mulch, project. Park playground mulch project.
Safety project.
Okay.
That's better, because it's got the words, can I make a recommendation, and we add something to title it, at least dated 9/3/25 or something like that. That's what we did last month, and that. I think we talked about putting a number on here, didn't we?
What do you mean?
Like,
Oh, putting on.
capital request form,
Yeah,
number
I
1,
forgot,
number
yeah, I
10.
forgot to add that, yeah.
But in the meantime, we could identify it by the date and the amount, up to 20,000. Those two things kind of tell you what it is. Playground stuff.
Okay. So,
If they agree with changing it and adding the date.
which date are you referring to? The 9/3/25?
The top date is the way they have it, yeah. So that's what we did last time.
But that's what's on their proposal already, it's dated already.
Right.
I think it has to be.
But in the, just adjusting the emotion to make sure that we.
So and
Can you
adjust
read
it,
back
you
the,
agree.
can you read back the motion real quick, just to make sure what you've got right now?
Do you want to with date or without?
It's,
What do you have written right now as is?
Motion by Ryan to recommend approval for spend up to $20,000 for park playground mulch safety project, seconded by Sam.
On proposal dated
3.
9/3/25.
9/3/23.
Do you agree with that
25.
addition?
I see.
Okay, so you,
Sam, you're my mind.
so Todd,
Yes.
so Todd, you keep your,
Sorry.
okay. So I have a motion and a second to approve this project. Any further discussion, or recommend approval of the project? Any further discussion? If not, all in favor? Aye. All opposed? Motion carries. Any other things
Yes,
for your liaison report?
yes. For, our our meeting was on the 3rd, and last month we had a motion to be able to have the Parks and Rec go directly to the trustees in order for detailed expense reports, approvals and stuff like that. It didn't pass last month, but I'm making a motion again this month for the same thing, that the Parks and Rec be able to go straight to the trustees committee in order to get approval on detailed expense reports.
So every month then, you're gonna have another thing, even though it was unanimous, no one voted against it, now we're gonna.
Hold on, we've got a motion, so is there a second? There's a motion on the floor to bypass the planning commission for detailed expense reports. Is there a second?
One second.
Okay, so I have a motion and a second to bypass the board, to go directly to the board of trustees for detailed expense reports. Any further discussion?
Yeah. That's not at all what was asked for, so that's a completely incorrect statement.
What are you talking about?
Read your words back, hear it again. That's not what was asked for the first time, that's not what was asked for the second time, and I don't see it in front of me either. So that means, once again, they didn't follow the rules. Where's the paperwork to say that?
You can't do verbals anymore?
Oh, you do a verbal motion, yes. It was never brought to us, though, is my point. It's not in here.
Not in our packet.
I'll give you another example. I wasn't gonna talk about this, because I found my own workaround. But if you look at this detailed request form, the bottom line, it says attaching documentation. This was not here, only because I questioned, where is this? A copy was provided to us before the meeting.
Everybody had that last meeting.
Nope, this is the new one, nobody had this last meeting.
This one right here.
Todd. This thing came up at your meeting just the other day for the first time. So we could not have had it before.
That's not true.
When did you vote to approve this?
Last month it was said.
Okay, wait, hold on. The motion that is on the table has nothing to do with this proposal.
Correct.
So, what is the wording of the motion exactly?
I'm going to withdraw my motion. I'm done.
I have a second, there's no reason to remove it yet.
It's already in the rescind motion, so. Any additional business on?
I'll make a motion to adjourn.
Can't be. I mean, you haven't had public comment yet, so you can't do that, so. Additional business, Monica, as everyone knows, has resigned to take the clerk position. You got a letter stating as such. Thank Monica for her service, and welcome Gloria to, as her replacement. Thank you for taking over, in her position, and then at the next meeting, which is the October meeting, we will vote for new, officers. That's why I did the secretary position tonight. Any public comment?
Yeah, actually, I have a public comment. I don't understand what the big issue is, why they just can't go to Parks and Rec, and they go back to the way they used to be.
That's
Well, why
why
was
it's
it changed in the
control.
first
I think it was changed in the first place, was you here?
Some people don't want to give up control. That's what it is.
The reason it was like that is because of Mr. Fall and somebody else, I can't remember who it was, they just didn't seem to agree on something.
It's
And at that meeting, the supervisor said, fine, just go to the front of the planning commission then.
It's too easy to sit back and poke holes in everybody else's.
I don't even know, I can't even remember if there was even a motion made on that.
Yes, there was. Supervisor made the motion to do it.
Yeah.
The supervisor
Well,
wanted.
I'll check that out, but I don't see what the planning commission, I don't see what the planning commission has anything to do with Parks and Rec.
So put that.
Okay, hold on, hold on.
And that's my end of my 3-minute speech.
Hold on. Now, when we started the process with Roe for the master plan and the zoning ordinance stuff, Roe found it extremely odd that the Parks and Rec Committee was doing the master plan all by themselves, that they were a complete separate entity. It is a very unique situation that was set up when the park went in. It is a unique situation. Even Roe thought they should be doing the master planning with us, because it should have been a committee of the planning commission. When Roe originally came in, because, what was his name? I can't remember the first name. Yeah, the guy before Alex. He was all like, so you guys are setting up these meetings for the Parks and Rec master plan together with the planning commission. And we said, no, they are a completely separate entity. He was taken by surprise when we said that, because that is not the normal case, because that master plan also resides within our master plan.
Right.
So it is very weird for them to not be a subcommittee of the planning commission.
There was talk about getting rid of the
Very
committee.
clear.
Tighter.
Very
Maybe
clear.
that's what we should do.
Instead of Parks and Rec is wrong.
Well, I mean, we're in public comment, so I don't want to have too much conversation on this, because we've gone past that, you've had your chance to talk about it, you rescinded it, and you threw all your stuff in your bag.
Exactly.
So we're not gonna go any further than to say, if you want to discuss it, then that's fine. Me personally, I saw the letter that was presented, there was no reasons given as to why that change should be made, just that you want to make that change. The letter that was presented to us at the last meeting only said that you wanted to make that change. It gave no reasons as to why to make that change.
Tuesday was a good excuse reason why I made that change.
Okay, but if you want to bring it up at the next meeting, if you want to have this discussion at the next meeting, I would put it on the agenda.
Honestly, I'm gonna put in a letter, I'm not gonna be on the Parks and Rec anymore.
Oh, okay. Any other public comment? Then I will make the motion to adjourn. I have a motion and a second to adjourn. Any further discussion? If not, all in favor?
Aye.